Why first-time home buyers must be 100% committed before making an offer. One of the most important lessons every first-time home buyer needs to understand is this. Making an offer on a home is not simply a way of saying, "I like this property." It is not the same as putting an item in an online shopping cart. It is not a reservation, and it is not something that should be done casually. When you submit an offer on a home, you are beginning a legal process that can ultimately lead to a legally binding contract. That is why before making an offer, every buyer should ask themselves one very important question. Am I truly prepared and committed to buying this property if my offer is accepted? Because once a seller accepts your offer, the situation changes dramatically. You are no longer simply looking at homes. You are entering a transaction that involves legal obligations, deadlines, financial commitments, and contractual responsibilities. And many first-time buyers do not fully understand what that means. Sometimes buyers become emotionally excited. They tour a home. They fall in love with it. They make an offer. Then reality sets in. They begin thinking about the mortgage payment, the responsibility of home ownership, property taxes, insurance, maintenance, closing costs, and suddenly they become uncertain. That uncertainty can create major problems. Because when a seller accepts an offer, they are making decisions based upon your commitment. The seller may stop showing the property. The seller may reject other offers. The seller may spend money preparing for the transaction. The seller may begin making plans for their own move. In many cases, the seller is relying upon your promise to complete the purchase. That is why buyers should never submit offers simply to see what happens. An offer should be made because you genuinely intend to purchase the property if all contractual conditions are satisfied. Now, let's discuss something many first-time buyers have heard about but often do not fully understand. Earnest money deposits. When an offer is accepted, buyers are often required to provide an earnest money deposit. This deposit demonstrates that the buyer is serious about the transaction. The amount varies depending on the market, location, and terms of the contract. In many situations, if the transaction falls apart for reasons protected by the contract, the buyer may receive that money back. For example, if financing is denied under a financing contingency, if significant inspection issues are discovered and contractual rights are exercised properly, if title problems arise, or if another contingency contained in the contract is not satisfied. However, if a buyer simply changes their mind without a contractual basis for doing so, there may be consequences. And this is where buyers need to pay attention. In some situations, the seller may have the right to claim all or part of the earnest money deposit. The exact outcome depends on the contract, state law, attorney review provisions where applicable, and the specific circumstances of the transaction. This is why buyers should always read and understand their contract thoroughly and consult with their real estate agent and attorney. Now let's discuss something that many buyers hear about but rarely encounter: liquidated damages. This sounds like a scary legal term, but the concept is actually fairly straightforward. A liquidated damages clause is a provision in some contracts that predetermines what damages may be owed if one party breaches the agreement. In certain transactions, the earnest money deposit itself may serve as the agreed-upon liquidated damages. In other words, the contract may specify that if the buyer defaults without a valid contractual reason, the seller may be entitled to retain the deposit as compensation. Now, I want to emphasize something very important. For most first-time home buyers, situations involving liquidated damages are relatively uncommon. Most transactions close successfully. Most buyers and sellers work through challenges together, and many contracts contain contingencies designed to protect buyers. However, the possibility exists. And because it exists, buyers should understand it before they ever make an offer. This is one of the reasons preparation matters so much. Before making an offer, ask yourself, have I reviewed my finances? Have I spoken with my lender? Do I understand the monthly payment? Am I comfortable with the location? Do I understand the condition of the property? Am I truly ready to move forward? If the answer is yes, then you can proceed with confidence. If the answer is no, you may need more time before making an offer. There is absolutely nothing wrong with taking extra time to think. What is dangerous is making a commitment before you are truly ready. Buying your first home is one of the largest financial decisions you may ever make. It should be approached with excitement, but it should also be approached with seriousness. A well-informed buyer is a stronger buyer. A prepared buyer is a smarter buyer. And a committed buyer is far more likely to have a successful and enjoyable home buying experience. So before you submit an offer, make sure you understand exactly what that commitment means. Because once an offer is accepted, the process becomes much more than simply finding a house. It becomes a contractual journey toward home ownership. Thank you for watching.